Welcome to the College of Labor and Employment Lawyers and the Metropolitan Washington Employment Lawyers Association's March webinar, Policy Debates, How a Defendant's Insurance Coverage Can Affect Employment Mediations. I'm Scott Oswald. I am MWELA's bench and bar chair and your moderator for today's program. Before we begin, Deborah Kelly, a fellow of the College of Labor and Employment Lawyers, has joined us, and she's going to tell us a little bit about the college. Deborah.
Good afternoon, everyone, and thanks for joining in this webinar on the policy debate on insurance coverage. Just a bit about the college. The College of Labor and Employment Lawyers is a national organization, and it is important because it's one way that we get recognition for those of us who've been practicing employment law for 20 years to join with other members of the employment bar, and it's plaintiffs' lawyers, management lawyers, in-house counsel, arbitrators, government lawyers. And we come together to try to both know one another, which adds to civility in the bar, and we have standards for admission, which we hope facilitates the way lawyers should act toward each other, which is we all have clients to represent, but we all should be decent and respectful and try to do what's best for the profession of the law at large in terms of advocacy, outreach, teaching, scholarship, and living by example in terms of what lawyers should be like. We also, in addition to getting to know one another and breaking down a lot of those barriers, because so many of us practice in different areas, we have CLE programs like today where we try to bring together topics that are of interest to members of the bar. So we are united within the various practices, and we are also coast to coast present. So once a year, we all get together around the same time as the American Bar Association meetings, and we welcome in the new inductees, and we have CLE programs at that time. So we hope you enjoy today. We hope you're interested in the College of Labor and Employment Lawyers. If two fellows recommend, then we go forward, and we're always looking to get new people in who would be interested in doing the mission and spreading the good word and increasing the brand and advocacy and research scholarship and of the College of Labor and Employment Lawyers. So thank you, and I hope you enjoy today.
Deborah, thank you. And now to our participants in today's panel. Ajmel Quereshi is a United States District Court for the District of Maryland Magistrate Judge. Before joining the court, Judge Quereshi served as the director of the Civil Rights Clinic at Howard University School of Law, as staff counsel to the American Civil Liberty National Prison Project, and as senior counsel at the NAACP Legal Defense Fund. In his role as a magistrate judge, Judge Quereshi serves as a mediator for civil cases preferred by the court's district judges. Nat Calamis is a member of Carr Maloney's Employment and Labor Law Practice Group, where he represents management in employment disputes. Nat has served as lead counsel in a number of bench and jury trials. Nat is a former president of the DC Defense Lawyers Association. Reuben Wolfson is a member of the Employment Law Division of Smithey Law Group, where he represents employees in employment disputes. Reuben has been recognized in chambers and in Best Lawyers. Judge Gina Sims, United States Magistrate Judge for the District of Maryland, won't be joining us today. She has had a death in her family. Thank you for understanding. I will take at least some of your questions throughout today's program. Please use the Q&A button at the bottom of your Zoom screen. We'll get to those, maybe a few during the program and a few at the very end. We are going to begin with a primer from Nat Calamis on the types of insurance coverage in employment cases. Nat, over to you.
All right. Well, thanks for that introduction, Scott, and thanks so much for having me here today. As you just mentioned, I'm going to give just a general overview of the role that insurance policies play in employment disputes. And I'm going to start just talking about the two main types of insurance coverage that typically gets involved when there's an employment law dispute. The main one is what's called EPLI, or employment practices liability insurance. And that's just your general policy that provides businesses with both defense and indemnity coverage. So it pays for the attorneys representing the companies that are getting brought into claims involving discrimination or harassment. And then it also pays out most types of settlements if there is a settlement reached or a judgment entered in employment discrimination harassment cases. Typically, these EPLI policies will not cover intentional torts such as assault or battery type claims. And they're also typically not going to provide indemnity for other types of claims such as breach of contract or any claim for unpaid wages. And then punitive damages is also something that is usually going to be excluded from an employment practices liability policy. Another type of insurance policy that comes into play at times in employment disputes is what's called D&O, or directors and officers liability policy. And that is a separate type of policy that companies can purchase that will provide defense coverage and indemnity for management employees or board members that get brought into cases individually. And that comes up a lot in this area where there are certain human rights statutes like the DC Human Rights Act, where it does provide for individual liability for managers. You can move to the next slide, please. Another concept that is important to understand in terms of dealing with these types of policies are deductibles. Most insurance policies in employment-related claims are going to have a deductible. And what that is really an amount of money that the company has to pay out of pocket before the insurance company starts chipping in and paying for either the defense or the settlement. The size of the deductibles really depends in large part as to the size of the company involved typically. So smaller companies are usually going to have smaller deductibles, where a large corporation is going to a lot of times have a very high what's called self-retention or deductible, where basically they're paying out of pocket for a significant portion of the defense before the insurance company even gets involved. So how that becomes important is, if it's a company that has a large deductible and they're still paying for the defense of a claim, they're usually going to have a lot more control over how the litigation proceeds and whether or not the case is going to be resolved at a mediation than if it's a case that has a very small deductible where the insurance carrier gets involved right away because they're the ones paying out the defense fees or any settlement that's reached. We can move to the next slide, please. And one thing to keep in mind when you're litigating these employment claims is that insurance carriers and the companies that they insure can, and in a lot of cases do, have very different views about resolving cases and whether or when a case should be resolved. And typically, claims representatives from insurance carriers are going to be looking at it from a much more strictly dollars and cents perspective, because a lot of them are handling 100, maybe 200 claims across the country. And they're just really trying to value how much is this going to cost if we continue litigating it? What's the downside risk? Does it make sense to resolve it early before we have to take on the expense of defending it, as well as the potential for a downside liability where, from the company's perspective, there could be other considerations, obviously, that the insurance carrier is not necessarily thinking about, such as, reputational harm, or just acknowledging, there's certainly a belief among certain individuals, particularly if there's an individual defendant named and accused of wrongdoing, that any type of settlement would be some type of acknowledgement of liability, or that they did something wrong. So there can be conflict that ensues between the carrier and the insured over those types of issues. We can move to the next slide. So from the insurance carrier's perspective, when they go to a mediation or ahead of a trial, they're always going to want a risk assessment from their defense counsel that they've retained to defend the case. And they're going to want, usually pretty detailed reports that builds in, what are the risks? How much is this, budget for how much the defense of the case is going to cost? A outline of, the potential damages that could be recovered if there's an adverse finding, and what the likelihood is of an adverse finding given the facts of a particular case. They want a summary of everything that happened and what the assessment is going to be as to what our chances are of prevailing, and if the case does go in favor of the plaintiff, what are we looking at in terms of potential damages? We can move to the next slide, please. And in terms of the damages assessment, obviously you guys are all well aware of this. In terms of types of damages in employment cases, you have economic damages for front and back pay. The carrier is going to want an overview of, is there a mitigation defense that can be raised that the individual involved in the case didn't take reasonable steps to find new employment after they left the employment of the company. And then compensatory damages is always a trickier issue to evaluate. Are there any medical bills for claimed emotional distress damages? Can we use that as sort of a baseline to assess, what kind of compensatory damages might be awarded if there's an adverse ruling? And even if you do have medical specials, which I'd say in the majority of cases I deal with, you don't, it's usually more garden variety emotional distress. It's tough to say whether that's an accurate predictor of what a compensatory damage award could be. They will want an assessment of whether or not there's a risk of punitive damages in the case, and then also an assessment of, the potential attorney's fee award if the plaintiff prevails, and what rates are being used. Obviously in DC, a lot of these cases use Salazar rates, which is significantly higher than what you're going to be dealing with in other jurisdictions. So all of those things, the insurance carriers want factored into an assessment prior to going to a mediation. We can go to the next slide, please. Other factors that are considered is, is there a chance of summary judgment based on the facts of the case and based on the jurisdiction where we are? What is that likelihood? Is there a judge that is known for ruling on motions for summary judgments in favor of defendants? Is there, are there legal arguments that can be raised in the case that do not involve disputed facts that could be a basis for moving for summary judgment? And then, if you're close, or even sometimes really, or a lot of times right at the outset of litigation, what would this look like if we took it to trial? Are the witnesses likable? Do they come across credibly? What is the jury pool that we're looking at in this jurisdiction where the case has been filed? Can we find, comparable jury verdicts that show the types of awards that can be given by juries in this jurisdiction in similar types of cases? And, there is, I'm saying here, it's as much of an art as a science. There aren't, specific metrics, I would say, per se, but obviously all of these things factor in, and what, based on these factors, the carrier wants defense counsel in advance of mediation to come up with some type of value that they think is a reasonable range to propose for potential resolution of a case. We can move to the next slide, please. In terms of when you actually get to the mediation, when there's insurance involved, who is coming to the table, who's actually going to be there. Obviously, defense counsel and a representative from the company that's being that the claim has been brought against will be there, and then there will be a claims representative from the insurance carrier. Obviously, when there are claims against individuals as well, there could be other counsel involved representing the individuals. And in certain instances, or I'd say in most instances, where you have a claim against a company and against an individual defendant, the insurance carrier a lot of times will split the file, and another claims representative will be involved for that other aspect of the case involving the individual. And, you know, generally speaking, what I would say is the more people that are present at a mediation, the more complicated it can become to try to resolve the case. So, you know, if there are two different claims representatives, sometimes there are claims that trigger two different insurance policies that could be from separate companies. You know, they're going to be arguing with each other about who should contribute what. There could be coverage issues where certain parts of the claim the insurance carrier is covering, but they're taking the position that other parts of the claim should not be covered. And that can lead to complications at mediation. So all just issues to be aware of. We can move to the next slide, please. And this is just kind of a summary, and I touched on this a little bit a minute ago, of barriers to settlement. Too many decision makers, when you have a lot of people in the room, that can make things more complicated. If there is a rift or a disagreement between the company and their insurance carrier, that can obviously be a barrier to settlement. You know, one side wants to settle it, the other side doesn't. That obviously creates issues. Coverage issues can be a problem. You know, the emotional nature of these types of claims can at times be, you know, a barrier to settlement if it's very, you know, personal allegations about conduct of an individual. You know, it's not uncommon for the individual involved to not necessarily want to resolve it, to want their day in court to, you know, to redeem their name or and not smear their reputation. You know, one last bullet point here that we raised, you know, a lot of times if the plaintiff side does make things very, very personal by, you know, demonizing the company that's involved or the individuals that's involved, that can make people dig their heels in a little bit more and make it a little bit more difficult to resolve things. And I think we're probably going to talk later about opening statements in mediations, and I'm of the mindset that those are almost never productive in these types of cases for this very reason, that the emotional nature of these types of cases can lead to, you know, particularly on the defense side, people getting dug in and being less willing to or open-minded about resolving claims. We can move to the next slide, please. You know, other barriers, just, you know, starting out with an extremely high demand that's not really based on, you know, any metrics or is not kind of tied to anything in terms of the amount of damages that a plaintiff could recover in the claim, I find is often a barrier to settlement. You know, if it is a case that the defense feels that they have defenses to, an unreasonable demand is probably going to make them more likely to say, let's just litigate this and try out our defenses and see if we can prevail. And, you know, even if in cases where the defense may know that there are risks and that there's, you know, bad facts on their side, you know, that risk can look more appealing if you go in and see a demand that's not really tethered in any type of metrics or recoverable damages. We can move to the next slide, please. Then looking at the flip side, factors that I find will favor settlement. You know, having individuals, defendants named, I feel like often create some impediments. So if it is a claim just brought against the company, that usually makes it a little bit simpler and easier. on the employer side, situations where the employer will often want to resolve cases, if they have a critical witness that no longer works for the company for whatever reason, that can be a factor in wanting to resolve cases. If an individual defendant is not aligned with the company, if they don't agree on exactly what happened, that can be, a reason to motivate settlement. Any type of, salacious facts or allegations of egregious conduct that could lead to negative PR for the company is obviously a factor. As well as the potential of a large attorney's fee award in cases that are going to involve, in-depth discovery disputes, litigation that's going to last a particularly long period of time. That's all going to be a factor. Realistic plaintiffs that, have not been oversold and tether their demands to, actual damages that they could try to recover, that's going to help motivate towards settlement. And then, whether or not discovery has occurred, obviously there are cases where you go into mediations pre-discovery or pre-litigation, pre-discovery, and you don't have a lot of information. But, generally speaking, I would say the more information that both sides have heading into a mediation, the more likely it's going to be that you understand the case and have an opportunity to assess its value and be able to hopefully resolve it. We can move to the next slide, please. Then what works from my perspective, I think I just sort of touched on this with the last comment, is just, having all the information up front. What drives me crazy is when I go to mediation, sometimes this happens, is, getting surprised by some fact in the case that, the plaintiff side discloses for the first time at the mediation, where, if I had known about it ahead of time and sort of been able to advise the company or the insurance carrier about it, that would have been built into the risk assessment and, would have been factored into the value of the case. In my view, it doesn't really do either side any good to hide facts if you're going to mediate the case that are going to be helpful towards getting the case resolved. So I think the more information both sides have going into a mediation about, the damages claim, what it's going to be, what it's based on, that's going to be more likely to lead to a successful mediation.
All right, we are now ready to move into the discussion portion of our time together. And I want to begin with Reuben. Really at the outset of a case, Reuben. So you've got a client who comes in or maybe talks to you on the telephone and you're kind of assessing that client, the client's claims. How early in the life cycle of a case do you value that employment case?
Thank you, Scott, and it's a pleasure to be here. So the answer is immediately. So in the consult, it's very critical not just to discuss the merits of a prospective client's claims, but also how damaged are they, right? If it's a case where they've been terminated, have they mitigated successfully? Is there a mitigation problem with their efforts to mitigate? Are they mitigating at a loss, or have they found replacement employment very promptly where they're making more money? All of those factors are going to determine how valuable their case is from a lost wages perspective. Of course, it's important to also go over other forms of damages with them up front, such as compensatory damages. You're going to want to talk about emotional distress. If it's someone who has emotional distress, are they treating with a physician or a therapist for that? It's a little bit harder to quantify emotional distress damages, but the actual damages should really be addressed immediately, because if you're looking at that case on contingency fee, or if the client is looking to retain hourly, they need to know the value of the case kind of upfront, at least from a ballpark standpoint. You also want to go over with them what statutes are in play as far as whether fee shifting applies or not. Is this a type of case where if they win as a prevailing plaintiff, they could move to recover their fees? Or is it something like a breach of contract where they're going to be responsible for fees, and they're not going to have that mechanism available to them.
You actually send a valuation letter to your prospective client right at the outset of your representation. Why do you do that?
Yeah, so one of the first things we do after getting retained, in addition to, of course, calculating statutes of limitation and gearing up for a demand letter or an EEOC charge or a lawsuit, whatever kind of phase we're at, is we're going to send them a letter on damages that sort of reinforces what we went over in the consult. Says, here's the statutes or claims that you have available to you that we're pursuing. Here are the types of damages available to recover. Here's the information that we need from you to be able to sort of put together a calculation, at least a ballpark of what your actual out-of-pocket losses look like from a back pay and front pay standpoint. It's also going to advise them if they have emotional distress damages available to them. It's going to advise them about emotional distress damages. And then certainly it's going to go over their duty to mitigate, because what you don't want to have happen is you have a client who's been out of work for 3 months, 6 months, whatever the case may be, due to a termination. And for whatever reason, they're not mitigating, or they found a mitigating position and they're not happy there and they're thinking about resigning, which could impact their ability to seek lost wages against the defendant in the case moving forward. So it advises them of the duty to mitigate as well. I think the more upfront you are with a client about how you value their case, the more realistic they're going to be throughout the case as far as settlement, especially as you're gearing up for a mediation.
So walk us through that calculation you put together for lost pay and benefits. When you're putting that together, what are some of the things that you're looking at for that spreadsheet you put together?
Sure. So I would say it's not a one-size-fits-all scenario, but in general, if it's someone that's been terminated, you're going to want to put in basic metrics regarding their lost wages. So what were their earnings? Salary, you're looking at bonuses. If it's a commission-based position, you're going to want to, try to factor in commissions. That may be a little bit more speculative. You're also looking at benefits. What was the value of the employer's contribution to health insurance? Was there 401k matching? All of those things are damages that you should be able to crunch numbers on and give them an approximation, even if you're not in litigation yet, where you would be hiring an economist to, provide an expert opinion on it. Practitioners are basically able to put together a ballpark, whether it's in a spreadsheet or some other form of a calculation, just to try to give an approximation of, okay, you've been out of work for a year. Here's what your back pay looks like based on your mitigation or lack thereof. Here's a period of front pay that we're going to put in this for purposes of gearing up for mitigation. That takes into account offsetting mitigating income that you've earned.
So let's talk reputational harm. Our clients come to us and they say, boy, this has really hurt my reputation. How do you give that meaning in your evaluation, reputational?
I think it's something that can be addressed both in economic damages as well as non-economics. So from an economic standpoint, the loss to reputation can be a factor in terms of front pay. How long are you seeking front pay? Are you going to hire a vocational rehab expert to talk about the not only the loss to reputation, but the labor market and, the person's ability to mitigate or lack thereof based on the circumstances. And then you can also address reputational harm in a manner of speaking through the non-economic side, through looking at compensatory damages. Reputational harm goes to someone's emotional distress, feelings, loss of self-worth, things like that factor into putting some type of a number into a settlement demand as far as compensatory damages for emotional distress as well.
You mentioned a vocational rehab expert, and that immediately triggers in my mind the possibility of kind of lost career opportunities for that employee. Is that something you discuss at the outset with your client?
It depends. If it's someone that's already successfully mitigated, it may be less relevant. If it's someone, for example, in an age discrimination case and they were a high earner in a very specialized position, there may not be a lot of opportunities for someone like that to find replacement employment quickly or at all. Those are the cases you're going to really want to look at whether a voc rehab expert, if you're in litigation, can help sort of bump up the settlement value of a case or bump up the value of a case for trial by really explaining eventually to a jury, what the labor market looks like, why this person has had such a hard time mitigating successfully. So those experts in tandem with an economist can be really helpful to explain and help value a case.
Mental anguish that our clients suffer. You work with your client on really giving that meaning through story. Give us a sense of how you put that together with your client.
Sure. So I think it's easy for someone to say, a plaintiff to say in a deposition or at a mediation or in another forum, look, I'm upset, I was angry. Generalized statements about emotional distress from a termination or other alleged wrongful act in an employment situation aren't overly helpful. Everyone sort of has, I think what Nat referred to as garden variety emotional distress. I think the clients who are able to help themselves the most are the ones that can really describe their emotional distress using specific examples of how it manifested in them, right? Did that termination cause them to gain weight, lose weight, drink more alcohol, sleep immeasurably more than they did previously, not be able to sleep at all, sit in their backyard staring off into space? And I think bringing those stories to light through other witnesses like friends or family can be helpful that really observe that person. And then, of course, you're also going to want to consider for litigation as at least, an expert, whether it's a hybrid witness who's a treating physician, a psychiatrist, a psychologist, an LCSW who can help provide testimony or medical records as to the extent of the plaintiff's treatment for emotional distress.
Reuben, we got a question here from the audience. How do you put a number on emotional distress damage?
Yeah, it's a great question. It's really hard to do, right? I think as far as settlement goes, you've got to explain to your clients up front that settlement's a voluntary process. And so in saying that, if you want to settle a case, you've got to have there's got to be give and take on both sides. And so coming in with a reasonable demand, say we're prepping for mediation, you can put a number on emotional distress using testimony from treatment providers, things like that. If the case is well into discovery, maybe there's been depositions along those lines, but it's hard, right? I mean, you're guided to an extent by the caps. So there's statutory caps, depending on the size of the employer for a lot of claims. If you're going into a mediation and the employer you've got is a large employer and you're capped out at $300,000, Nat on the other side or Judge Quereshi or whoever your mediator is probably isn't going to take kindly to demanding the statutory cap at a mediation for emotional distress. That's not realistic. It's not something your client's going to get in mediation. So you've got to kind of discount for the phase of the case that you're at. And mediation, usually you're to come in with, in my view, something with less than six figures in emotional distress damages. Because at the end of the day, defendants typically don't care how a plaintiff views a global amount, right? They're not so worried about whether a plaintiff thinks of, I'm getting $25,000 for emotional distress and $50,000 for lost wages. They're just looking at a lump sum amount typically. And so the emotional distress value is hard to quantify, but you try to discount for the phase you're at if it's mediation.
Reuben, do you factor the risk of loss at summary judgment into your valuation pre-summary judgment?
Certainly, yeah. And I think it depends in large part on the forum. So like in Maryland, for example, if our case is in state court, we're probably going to put a lower risk assessment to the client on losing at summary judgment. We just find that it's a lot easier sledding to overcome summary judgment motions in state court. The federal bench, we're probably going to have to assign a higher risk on summary judgment. And that's something you're talking about with the client throughout the case. Certainly as you get into litigation and in gearing up for a mediation, you've got to go into mediation with a ballpark amount of what your client's best day in court was, right? If the case was being tried tomorrow, here's your best day in court. And then you've got to account for risk. And part of that risk is your odds on summary judgment. And that's going to be a really case-specific analysis, but also a client-specific analysis. What type of risk tolerance does your client have? Some people are very risk averse. Risk averse people might not even get to litigation, right? But if you have a client who's really willing to roll the dice and they say, I'm willing to accept the risk on summary judgment, maybe you go in with a more aggressive demand. But you've got to be factoring in summary judgment briefing at mediation.
Reuben, thank you. Judge Quereshi, I'd like to bring you in at this point to talk maybe about the attributes from your perspective of an effective employment dispute mediator. What are some of the attributes of a mediator that a successful mediator of an employment case from your perspective?
Sure. Thanks so much to all of my fellow co-panelists for being here today, and thanks to all of you for tuning in. That's a great question. I'm very honest in all of my mediations. I sort of say up front at the beginning, how long I've been on the bench. I've been on the bench for 11 months. So that shapes my perspective. Obviously, it's different than my perspective in month 1, but it would be different from the perspective I'll probably have in year 11, knock on wood, if I get that far. And I sort of say at the beginning how many mediations I've done, and I give people a sense of what I bat in terms of being able to settle cases. And I can say that before I joined the bench, I watched three other magistrates on this court do mediations, thinking that I would be able to imitate what they did in terms of their style. And what I learned fairly quickly is that each of them were effective. Each of them were able to settle their case, but each of them had very different styles in terms of the result that they reached. And so Mr. Wolfson, I think he's hit all of the points that are right and effective and meaningful, and Mr. Calamis has as well. But I think you really sort of have to know your mediator, because I think what will be effective before one mediator isn't going to be effective before another mediator. And I think you have to understand your mediator style. And so I can talk about being self-reflective when I think I have my best day, what I'm doing well, but that may not be the style of a different magistrate judge in this courthouse or a different magistrate judge in this court, and certainly not a different magistrate in another court entirely. So you need to know your mediator, what their styles are, what they respond well to, and how fast they go, how slow they go, how much they talk, how much they listen, what the mediator's background may be, what their biases, conscious and unconscious, are. All of those, I think, are relevant to assessing what makes that particular mediator effective on any particular day. So with all of that as a caveat, I can sort of say general things about what I try to do, and I emphasize try. I mean, ultimately, you'll have to ask the people who've actually been before me as to whether or not I'm actually effective. And so I'm leaving that out there as a huge caveat. But I think what I try to do to be effective is, number one, I try to prep it really hard. And so I say at the beginning that I prep every single mediation the same way that I would prep it if I actually was hearing the motion for summary judgment that's pending. So that means I read all of the exhibits, I read the entire docket, the answer. If there's been a decision on a motion to dismiss, I read that as well. Of course, I read your ex partes. I Google all of the lawyers and read their bios. And if they've been involved in news on the internet and press releases, I read all of that as well. I take into particular account, if it says something about what they do extracurricularly, I look at that as well. I mean, mediation is a relationship game. So I think that's point number 2. I think that you have to build trust with the people that are in the room, and that takes time. And that means, knowing what they're about, having a sense of what their backgrounds are, having a sense of the way they work, what they think, again, what their biases may be, conscious and unconscious. I think all of that goes into it. So all of that is sort of under part number 1 of the umbrella. I think you have to prep it really hard. And so I read everything out there that there is to know. Point number two, and this goes contrary to point number one, is that even though you've done all of that prep as a mediator coming in, I don't think at 10:15, my mediations all start at 10 a.m. to give you a sense. They start at 10 and I'll go however long need be. At 10:15, I don't know that I want to lay on everybody in the room my thoughts and exactly how the case should end and how it should settle. Even if I have thoughts as to sort of where we're eventually going, or ultimately how a jury or a judge, the judge that the case is before, would ultimately rule on a pending motion in the case. Because the truth is, and I'm very conscious of this, I have no power in a mediation scenario. The only real power I have is soft power. The analysis I always use, or the analogy I always present, is that you can't be a hammer in a mediation. You have to be water over rock. And so coming in at 10:15 and laying down my self-perceived brilliant analysis of how the way the case should come out, not only will it have no effect, it likely will alienate probably both parties in the room. And so I think you have to, in addition to prepping it really hard, you have to be careful in terms of how you use that prep. And you have to be conscious of the fact that it really is a relationship game, as I mentioned it. You have to get the parties to trust what you're telling them, because in that scenario, you don't have the power to order them to do anything. So to the extent that they're going to buy your opinion, you have to demonstrate to them that you've put in the work and put in the time, and that you really know what the case is all about. And then finally, I think from my perspective, what I've found works for me on my best day is, and contrary to what you may be thinking at this exact moment, you have to be a good listener. I think one of the things that I knew coming in to being a judge, but I think about every single day as a judge, is that every day that somebody comes before me is the worst day of their life. Plaintiff and defendant, corporation and individual. And again, that means that I can't come in at 10:15 and try to wow them with my prep, or try to tell them about my deep thoughts and statutory interpretation, or some footnote from another judge in this district interpreting a similar case. It's about me making sure that I spend the time to really hear their story. And Mr. Wolfson and Mr. Calamis have talked about this already, and make sure that they're being heard. Because I think for many of them, it may be the only time that they get to talk to a judge and have a judge listen to what they have to say. And for the other ones whom it's not the only opportunity, they're not going to get that opportunity for another, year and a half when the case actually goes to trial. And so Mr. Wolfson has talked a great deal, rightly so, about risk. But I think the other thing I always emphasize at the beginning, after I finish listening, is the delay of perspective, piece of it as well. So, I think it's those three things. It's listening, it's prepping, and then I think it's patience, knowing when to use the work that you've put in.
Judge Quereshi, we have an audience question. Is it helpful or harmful for parties to begin engaging in settlement negotiations prior to arriving for the mediation?
Very helpful if it's not posturing. So, if you're just doing it to set up what you're going to do during the mediation, which is, what do I mean by that? Starting really low and on one side and starting really high on the other, and then not really budging because you want to demonstrate to the other side that you're going to take a really hard line in the mediation, then it's not effective. Then you're just engendering bad feelings, and you're wading into some of the emotional issues that Mr. Calamis highlighted in his PowerPoint. But I think if you actually want to do it, I tell them in my letter order that goes out to begin exchanging offers a month beforehand. And the idea is that if they exchange offers that early and actually continue to follow through on it, as I instruct them to do, although not everybody always follows my instructions, I'd say probably somewhere between 5 and 10% of my settlements settle before they actually get to the settlement, because they've already been involved in those communications. And the truth is, I pride myself on my accessibility. So, I think that if you actually want to have a conversation with me about the case before you get there, and I can be helpful in getting the parties through a shuttle diplomacy to resolve the case because they've engaged in that back and forth before the actual quote unquote mediation, I'm happy to do so. I had one just within the last couple of weeks where, both the parties called me the day before and said we're pretty close. And within a matter of 2 or 3 phone calls on both sides, I was able to get the case settled the night before the actual mediation.
Judge Quereshi, we have another question. The mediation is likely the plaintiff's only day in court, and I find my clients are often very disappointed when the judge does not take the time to talk and to listen to them and just talks to me. How do you handle this?
So I do the same thing. As you can tell, I love the sound of my own voice, so I have to really tamp it down. But I always go into the plaintiff room the first time. And again, there's no grand secret here. I don't think that this is giving anything away to defense counsel. I've usually talked at them already for about 5 to 7 minutes. So I begin every mediation with the joint session. And I think Mr. Wolfson is right. There's usually not an opening statement from either side. I usually just sort of lay down the rules of the road, tell them what my schedule is like for the day, which is usually the whole day is wide open. I tell them about my background, what I did before I joined the court, tell them about how many mediations I've done, what I bat in terms of landing mediations, tell them rules of the road, pretty basic things like, everybody's going to have to move and everyone's going to be unhappy at the end of the day, including me. So they've heard about 4 or 5 minutes of my prattling in the joint session. And, that really is enough that anybody should have to listen to. And as soon as I get into the plaintiff room, the first thing I say is, look, I've read everything, which I have. I generally read everything. And then I say, so you can go over points that you want to go over that you think I may have missed, or reemphasize points that you think are important, or you can just talk to me about your case. And I say that to both the lawyer and the attorney jointly together. And usually the lawyer goes first. And then once the lawyer has finished, I usually say to the individual client with the lawyer present, is there anything that you'd like to tell me about? And then I just listen. And oftentimes, that can be 10, 12 minutes of just listening to their story. And then I say to them, and again, I'm very honest about this. I have very little hard power in that scenario. The only power I have is water over rock. And so I say to them, I understand, which I do. And then I usually, I think it's meaningful for them to hear this. I tell them, personally, I'm very sorry for what you've experienced. And I am in that moment. I usually am very sorry for what they've experienced, right or wrong. Their fault or not their fault, they've experienced some trauma. As I've said, on both sides, every time somebody comes before me in any context is the worst day of their life. And I'm very conscious of that. And so I tell them, I'm sorry. And, I think that those two things together, making sure that in every single one, I ask the plaintiff if they want to talk and then give them as long as they need. And then just telling them that I'm personally sorry for what they've experienced. That's powerful. I think that's powerful for any of us. I think all of us want to be told that somebody empathizes and sympathizes with anything we're going through in any of our lives.
Judge Quereshi, what are the things that employee counsel should provide the defendant before mediating the case to maybe maximize the employee's chances of successfully mediating that employment dispute?
So I think a lot of that is in my standard letter order, which I'm sort of looking at one right now. Some of the things are pretty basic that Mr. Calamis has talked about already in terms of insurance caps and what those caps are. I think usually most of the time, plaintiff's attorneys at the end of the day will not be seeking a number near that cap. Usually. Now, there are some exceptions that can be sort of frustrating and difficult. I think it also is helpful for it to come out at some point. It doesn't have to be beforehand, but at some point during the mediation, what the costs of litigating the case all the way through will be for defense counsel. I think that's helpful as well. I think obviously it's really helpful when you put forward what you think your strongest legal and factual arguments are. So if there's been a motion to dismiss or a pending motion for summary judgment, those arguments are already out there. But if not, it's helpful to have a respectful conversation either over email or over the phone about these are what we think our strongest points are, just so that everybody is aware of it going into the meeting. And that way, Mr. Wolfson or whoever's on the plaintiff side can prep their client for what some of those really strong arguments are going to be. Again, I think that what I've found to be really effective in a mediation is that fine line between zealous advocacy and posturing just for the sake of posturing. And I think that I ask for, in all of my letter orders, for the parties to tell me not to be shared with the other side unless they give me permission, what the strengths and weaknesses of their case are. And the effective mediation statements always acknowledge at least some weaknesses. But, I still get them. And, I've had some recently where people have come in and said, our case is perfect and we have no weaknesses. Well, fine. I mean, that's fine, but that's going to make for a really long day for everyone. Because the truth is, and this is what people often, and I'm hitting it for the third time. There's nothing that I would, as a judge, would love more than to decide your case for you. That's obviously the part of being a judge that's most interesting to me as a former litigator intellectually. But that's not a power that I have on the day in question. And so if you're going to come in and say, we have no weaknesses, we're entitled to everything. Tomorrow will be mediation 71 for me. So it gives you a sense of how many mediations I've done in 11 months. And I've been told that's about average in this district. So about 75 per year is what most magistrates average. And so it gives you a sense of how many mediations magistrates do in a short time. In the 70 I've done beforehand, as of yet, I've yet to convince anyone that their position was entirely wrong and that one party was entitled to everything. But who knows? Maybe 71 will be the charm, and I'll finally be able to do it.
You talked about listening to the plaintiff. I want to now focus on listening to the employer in the mediation. From your experience, what are some of management counsel's concerns going into an employment mediation?
So I think it's usually, and I think Mr. Calamis rightly hit on this, I think it's oftentimes how high plaintiff is starting and the lack of damage basis for the number that the plaintiff is starting with. And I think Mr. Wolfson hit on this as well. There'll be specials, there'll be garden variety emotional damages, there'll be lost wages, medical bills, things like that. And then there'll be sometimes a six-figure number on top of that, sometimes multiple six figures on top of that for just general suffering. It's always something that I'm thinking about as a mediator is to the extent which plaintiff has had those hard conversations with their client about how much of that is actually attainable during a mediation. And that's something that defense counsel often doesn't know. And so defense counsel oftentimes sees this really big number that oftentimes will be different than where the case actually can settle. And they'll have serious concerns that either plaintiff's counsel hasn't had the hard conversations with the plaintiff about what actually is attainable in a mediation, or that both plaintiff's counsel and plaintiff together don't recognize, again, what's actually attainable in a mediation. So that's what I've found to be the most significant concern is when the number starts really high, there is this question of, again, you see the same things over time. So you have a sense people will move, and you oftentimes, believe that the actual number will be lower, but there's always this fear, or at least a shock factor, when they initially see what the demand is.
Judge Quereshi, we have a question from our audience about opening statements. There was a reference against opening statements being off-putting. Isn't there value in letting allowing the employer to assess the plaintiff as a witness?
So the question is interesting because it asks for an opening statement from the other side, in terms of how do you don't want to give an opening statement yourself. You want to elicit an opening statement from the other side. I think that is tough to facilitate. And And I think that as a mediator, I potentially would lose credibility if I came into a scenario, a mediation where I had not met the parties before and had not met the employee and tried to push the employee into a scenario of the equivalent of testifying so the other side get information. I think that I respect the desire to get that piece of information. And as I always say at the beginning, part of my job is, even if we're not able to settle the case, help you get more info about the way the other side views the case. I think that part of the art, as Mr. Calamis talked about at the beginning, is doing it in a gentle way where I'm making that assessment in my communications with the plaintiff and then coming back and giving you an honest assessment of what I think as to their presentability. I think there's risk for me and a mediator in sort of facilitating and pushing that right at the beginning, because I potentially may lose credibility with the party in terms of them wondering why I'm pushing them to give an opening statement.
Another question from the audience. It relates to when there's an insurance adjuster in the room. I know that former Judge Howard Chasnow used to require the parties give opening statements when it was an insurance case with the adjuster in the room. Is that something that Bridge, you've ever crossed in your mediations or considered at all, the value of an opening statement when there's an adjuster who's maybe hearing it from the other side for the first time?
I think I keep going back to what, and again, I think this is why I gave you the caveat at the beginning that every mediator is different. I think for me, again, query whether or not this is actually true or not. I mean, again, who knows? I think my style is one about trying to keep temperatures pretty low. And I think that that's part of my job as a mediator, is that y'all yell at me and tell me how angry you are at the other side and how what they're doing is ludicrous and how this is a nuisance case, and conversely how there's been irreparable harm. And then I think I filter that out and decide to give which portions of that I actually give to the other side. I never take 100% back what one side gives me to the other side, because it would blow things up. I think that that's part of my job. And so I think that I think I respect the role that insurance adjusters play. I mean, they have a tremendous amount of experience and they come into the case with metrics, but I think for the same reasons that I usually don't ask plaintiff to give an opening statement, I don't ask insurance adjusters to either. I think all of us have a limited perspective on what's going on. A former litigator like me thinks about things mostly through a legal perspective. That's why I told you I read everything out there. The plaintiff thinks about things through their personal experience. And the insurance adjuster, as Mr. Calamis talked about, views things through metrics. And so I think part of my job as a mediator is to hear all of those, mesh them together, and then help the parties reach a result that combines all of those perspectives. So I don't know that like asking for the insurance adjuster's perspective at the beginning would be helpful. Again, they have an important perspective, but I think it would dominate over the other perspectives, which are just as important.
Thank you. Another question from the audience. What else could the parties provide you to help to assess valuation? Things like comparable jury verdicts, medical documentation, and the like. Anything like that helpful?
Depends on if you're talking about from the plaintiff side or the defense side. So, I'm looking at a sample letter order of mine now, and I'll just tell you what I asked for. And I think this is, I put it together at the beginning, and it's a fairly long list. And so I'll go through it now. It's all your strengths and weaknesses, an honest assessment of your strengths and weaknesses. You don't have to sort of say, look, we have these huge gaping holes, because the truth is that I'll know it when I read the docket and read the case. You don't have to totally fall on your sword, but some acknowledgement of what your weaknesses are. I ask for all the facts that are material to the case that you believe you can prove at trial and how you would prove them. I ask for all pending motions, the date that they were filed. I ask for an evaluation of the maximum and minimum damages awards that are likely. Most folks are pretty honest and straightforward on that one, I ask for, if it's on the plaintiff side, an itemization of the plaintiff's damages. I ask the defendants if lack of financial resources is an issue, and if so, what financial resources do they have? About 10% of the time, that is a potential problem, especially when insurance isn't involved. I ask for copies of emails setting forth the settlement negotiations to date, so I can actually know what communications you've had about settlement. As I've mentioned this already in response to your earlier question, I ask for attorney's fees and costs of litigations through trial for both sides. I hint, but do not demand, that at some point during the negotiation, I may ask about what the attorney's fees arrangement is. Of course, you don't have to answer that. And then I ask for the names and titles of the people who will be attending so I can Google you beforehand and get a sense of what you're about. Again, I assume that everyone preps for these things as hard as I do. So I assume everybody has Googled me and read about all my failures before I became a judge.
Judge Quereshi, thank you. Now I want to bring you back in at this point and just, a sense of, you and I've talked about this, that there's EPLI coverage in many more of our cases today than, let's say, even a few years ago, and certainly a lot more than a decade ago. Why do you think that is?
Well, I think there's more risk for these types of claims that, so the EPLI insurance is a risk management product that's being sold. Insurance companies make money selling the product. And, I'm surprised how often I talk to employers that don't have it. In DC, you can have any number of them. If you have a single employee, you're subject to the DC Human Rights Act, and you're potentially individually liable for, some of these claims. So I think it's very much advisable for companies of any size to have these policies. And then obviously when claims come, they're going to come into play.
You mentioned coverage for some claims and maybe not for others. What's a reservation of rights letter?
Yeah, so that when a claim comes in, either whether it's a lawsuit or a demand letter or an EEOC charge, the insurance company will look at it and send out a letter to the company that says, here's what the allegations are. We're going to provide you with coverage for X, Y, and Z, but there are also allegations of this other sort that may not be covered. So we're reserving our right to determine whether or not we're going to provide coverage at a later date. So it's basically just lays out at the outset of the litigation what their coverage position is, and they can sometimes send updated letters as the litigation proceeds.
And as a practical matter, what does that mean for the client who's receiving that reservation of rights letter?
It means that if there is a potential judgment for a claim that the insurance carrier decides is not covered, then they would be liable for that without, the insurance carrier providing indemnity.
Let's talk about a particular kind of claim, negligent hire and retention employment claim. What kind of potential policies that the employer might have might be triggered by that kind of claim?
I have seen that covered by EPLI policies, but I've also seen issues where it will trigger a general liability policy as well, because it's a negligence type claim. And when that can create some complications, because it can sometimes mean that another insurance carrier is going to get involved in the case. And often if you're dealing with a general liability policy, you're going to be dealing with a claims adjuster that doesn't necessarily have much experience in the employment realm. So it's just something to think about.
Got it. We have a question from the audience. Can you talk more about the 3 times medical related to economic damages slide?
Right. I think that was really more of just an example of ways that, carriers can look at, calculating, potential exposure. It's not meant to say that that's a baseline that all carriers follow all the time. I know in the personal injury realm, there are sort of calculuses like that. That I haven't really seen that's followed, but it's necessarily, but looking at the specials and coming up with some type of metrics based on the specials is sometimes looked at.
For coverage under an EPLI insurance policy, what's the dividing line between intentional torts that won't be covered and other claims that will be covered?
I don't know that I could list every example, but assault and battery generally are not going to be covered by a EPL policy. Intentional infliction of emotional distress, something like that, is generally not going to be covered. Wage and hour. I'd say the most common coverage issue I deal with is a claim that has a wage and hour component and then some other, discrimination, harassment component. And there are policies that provide defense coverage for wage and hour claims, so they will pay for the defense fees, but just as a matter of policy, insurance companies do not insure for any wages that were not paid.
What about sexual harassment claims?
Those are generally covered, both defense and indemnity.
And discrimination claims, those are generally covered?
Yes.
We have another question. How common is it for an employer to contribute money to a settlement over and above its retention amount, notwithstanding the coverage for liability fees by the insurance carrier?
I'd say it's uncommon. I have seen it happen. I'd say the more common scenario than that is the situation where the insurance carrier wants to settle the case, but the company does not. In terms of the conflict I deal with, usually I would say if there's a desire from the client to settle and there's downside risk, the insurance carrier is gonna kick in. The other issue where I see that sometimes is if there is a coverage dispute where it's a claim that has, say, a wage component, and the insurance carrier says, "Look, that's the main crux of this claim. If we're going to need to resolve it, then there's going to have to be, some contribution from the company." And that always puts me, if I'm being brought in from the insurance carrier, in a very difficult spot, because I can't give advice one way or the other to either the insurance carrier or the company about what they should do in that situation. And a lot of times, my job is to, if you can foresee those issues coming about, you need to get them sorted out ahead of time, in advance of the mediation. You do not want that to come up for the first time when you're sitting there trying to get the case resolved.
So when there's that kind of dispute potentially between the client and the insurance carrier, how do you deal with that issue?
I tell them that they should seek outside coverage counsel to give them advice on what to do. I'd say that to the company. The carrier, I don't really need to say that to. They have their own coverage people that handles that.
Let's talk about the potential for reputational harm to the reputational risk to the employer. Is that a factor in potentially a case that might be appropriate for an earlier type of mediation?
Yeah, absolutely. It's definitely anything that has the chance of getting negative publicity, or if it's a particularly egregious fact pattern, then that's something that's going to be considered. Not necessarily by the insurance carrier, but certainly by the company, and the insurance carriers aren't oblivious to it. I think they understand that if a case has the potential of getting a lot of publicity, that's going to drive up the value of it. So it's definitely something that's considered.
You mentioned uncapped damages before. Is that a factor in kind of how you assess the value potentially of a case?
Yes, definitely. Yeah, I mean, if you've got a cap on the amount of damages that takes away some of the downside liability. But yeah, when you've got a situation where it's uncapped, particularly if it's a sympathetic plaintiff or a client that you have concerns that a jury could get angry with, then that's definitely a factor.
You mentioned the jurisdiction in which the case is filed. How about the demographic makeup of the jury pool in that jurisdiction? Does that play into the risk assessment?
Depending upon the case, sure. If it's a race discrimination claim and the jury demographics is such that that they're similar to the race of the plaintiff, then that's going to be something that gets factored in. Not in every case, but definitely in certain types of cases.
Another question from the audience. Nat listed contingent fee plaintiff's counsel as a factor in mediation. Can you expand on whether the plaintiff's attorney is contingent or hourly, how that affects things from the defense perspective?
I don't know that that's a major factor, but if it's, it could come into play in terms of the costs that are expected to be incurred in, a contentious piece of litigation. If there's going to have to be experts retained, and that's, that could be a point of leverage, honestly, on the defense side, that that they're going to have to pay out those costs, and that it's not necessarily something that is discussed in a mediation, but it's definitely something that's factored in.
Judge Quereshi, I'd like to bring you back in if we could. And we're back in the kind of the situation where you've got two parties in the other room, the insurance adjuster and the employer counsel. The question from the audience is, how do you deal with a situation where there's EPLI coverage or some sort of insurance coverage and a comprehensive mediation at the defense attorney and the adjuster strongly recommend a settlement figure ultimately suggested by the mediator, and the employer owner does not want to settle that case? How do you deal with that?
Yeah. So I think that at that moment, respectfully, as kindly as I can, I think that is the moment where you sort of walk through all of the legal holes in their case. And I think that because at that moment, the lawyer is on board, and the insurance adjuster is on board, and it really is just the client. And more likely than not, they may or may not have as much legal experience as all of the other folks on the call. So that is that moment where all right, this is the time to lean into, number one, the case law in terms of how those cases have played out. I have records that I keep of jury verdicts in the district. So I walk through the evidence that I have about what similar jury verdicts can be in similar types of cases over a period of time based on the data that I keep. And then in that moment, you also walk through for them what the costs of litigating the case out will be. And so I think that is the moment where you sort of hit all three of those factors. And then still, if it's still not coming around, you have to make a judgment call. As I said at the beginning, a lot of doing mediation, doing it well, is reacting to individuals' emotions in the moment and trying to read how they're reacting to what you're giving them. And then you make a judgment call of, do I continue to press on this? Or do I give them a little bit of time now to go back and convene with their team once more and see if they come back to the same place? I mean, two final points on this. I think that's why I really do tell everybody at the beginning, we're all going to go home unhappy at the end of the day. And then I sort of tell them at that moment, again, this is that moment where we're all unhappy, including me, which is fine. And still, if they've gone back and this has happened and they've talked with their counsel and talked with their insurance adjuster and they're still not there, then I go to the other side and say, give them a week to sort of come around on it. And that gives times for emotions to settle, for there to be more conversations, for hopefully the insurance adjuster and the counsel to reemphasize the points that I've made. In most of the time, the employer does come around.
Judge Quereshi, thank you. Reuben, I'd like to bring you back in here. We got a question from plaintiff's counsel's point of view. Does the presence of EPLI generally help or hurt the chances for settlement in a mediation from your perspective?
I think generally speaking, it can help because, a lot of the decision making without insurance coverage on both sides of the table is driven by emotion, whether it's a plaintiff or, a CEO or someone from the company on the other side. And so anytime you can take some of the emotion out of the decision making process, I think it can be helpful overall. Yeah.
Thank you. Nat, back to you. How much power does the defendant company have in convincing the insurance company to settle when there is a conflict between the carrier and the company with respect to how they handle the settlement, such as when the company wants to settle and the carrier does not?
It depends on the company. How is it, that I sort of touched on that with the deductible situation. If it's a smaller company that has a $2,500 deductible that's already exhausted, and it's all the insurance carrier's money, then, they don't have a lot of control over convincing the insurance carrier to settle if the insurance carrier doesn't want to. Now, but like I said before, that is sort of a pretty rare scenario that I would say where it's the insurance carrier that's the roadblock to getting things resolved. I usually deal with it more on the other side where it's the client doesn't want to settle it and there's non-monetary terms to the agreement that the insured will not go along with, and that's more of the roadblock. But a lot of the policies have something called a hammer clause in them, and basically that will say that, if the insurance carrier deems a settlement is reasonable that the client doesn't want to go along with, if there is an impasse on that and the case goes forward, it shifts some of the liability exposure to the insured. And they have different types of provisions and different policies, but that's something that doesn't come up often, but it can.
Now, another question, are there specific points at which the carrier adjuster are willing to reevaluate their initial evaluation of the case?
Yeah, they ask us, if it's a case that gets into litigation, they want us to provide regular reports. So there's typically an initial report just based on, whether it's the demand letter and the initial investigation of talking to witnesses. And then there's usually going to be a follow-up report after discovery has been conducted, if depositions are taken. And then, they'll usually want to report before mediation, a report before trial. So, things change, different facts can come out in discovery, and they can reassess their position.
Let's talk about the situation where there might be several parties in that other room, Nat, the joint employer scenario. How does that impact the overall dynamics of a case, both at the beginning and then, as the case proceeds through litigation from a settlement position?
Well, it depends. It can become an impediment if one side of the joint employer relationship takes a hard line stance that they are not the employer and they're not contributing anything. But at other times, it can be helpful because it's if there's two companies or two insurance carriers involved, it could make it more likely that the case can get resolved.
Judge Quereshi, we have a question about mediator's proposal.
Yeah.
Do you give them, this is when you suggest an amount to each side individually, and when? If so, when?
For me, that is close to a last resort. So I think that if I've done everything else, so usually second to last resort for me is bracket. Not by me, but usually it's going to be dueling brackets from the other side. And then they'll either settle on a bracket in between, or that'll give them a sense of how far the other side is going to move. And then I think when it's a combination of two things. It's last resort, as mentioned. So really it's nobody's moving anymore. And there's a level of frustration, I think, that I can palpably sense that The only way we're going to be able to get this thing over the line, and I think I have to think critically too about whether or not I've gotten to the point in the relationship with both sides that if I give them a mediator's proposal, they're going to see it as an unbiased proposal. And what I always tell them is I'm very clear that a mediator's proposal is not what I think would actually, I mean, it's based in part on what actually would happen. It's based in part on the law and the facts, but it's based primarily on what I think actually will settle the case. And so I think if all of the tricks of the trade have been tried and we're at that point where nobody's moving and everybody's frustrated, and I think that if I've built up the trust enough with the parties that they'll actually take seriously what I propose, then I'll propose it. I usually will have a sense much earlier in the day of where the case could settle, and I'll sort of sit on it until we're at that point.
Judge Quereshi, thank you. Nat, back to you. Early mediation, what types of cases are well suited for early mediation, maybe before even the discovery has begun in the case, or maybe even before filing the complaint?
I think if there's a case where there's a PR concern from the client that they don't want a public filing, making some of the allegations, and a lot of that, if you have a case with egregious sort of sexual harassment, sexual assault type claims, that's, you can investigate that really without going too in depth into discovery. And I think those are often ripe for early type mediations. But anything really where you see right up front that there's exposure and there's fee shifting. So if I litigate this, the cost is just going to keep going up in terms of the settlement value of it. So, any of those can factor into a decision to mediate early.
We got a quick question here on coverage in wage disputes. You mentioned before that generally they're not covered. The question is, does insurance coverage cover the multipliers applied by the statute? For example, in DC, the statute provides for treble liquidated damages. Would the liquidated damages be covered?
No, in my experience, none of the wages or the multipliers would be covered. It's really just certain policies provide for defense costs.
Are there times when the insurance carrier does not want to issue separate checks for attorney's fees and emotional distress damages? And if so, when?
I have not seen that. Typically, most of the cases I'm involved in, because there's typically a wage component of it too, the insurance carrier will send a check to the insured, and then the insured cuts different checks to the plaintiff. That's typically the way I handle it.
Judge Quereshi, any specific strategies for dealing with a moment when both parties say they have given their best and final, and they're $10,000 or $20,000 apart?
I mean, that's, I think, one of the things that's been most interesting and was most illogical, or would have been most surprising to me before I started the job, is that oftentimes when the parties come in 6 figures apart, that's going to be much easier to settle than a case where they're 4 figures apart. Because I think once they come to you and if at the beginning of the day they're only 4 figures apart, it means they've done a lot of the easy work, and now they're down to the really hard parts. I think at that point, what you do is you walk through with them what the likely way the litigation would unfold, which means oftentimes there's going to be some sort of additional depositions that need to be done, as well as additional experts that need to be retained. Those experts need to be deposed. If you retain an expert, the other side will retain an expert. And those will be additional costs. So you just do the simple math right there, and you walk through how much it's going to cost to litigate the case going forward, including potential briefing. And oftentimes that will eat up the difference, although it's very rational in that moment. Oftentimes, again, no one changes their mind on a dime. It's just not the way, especially in these emotionally charged environments. So I think you have to feed that to people. You hope that then the counsel will be able to have the conversations where they reemphasize the points to the client, because usually it is the client at that point, because it's emotion at that point. It's a matter of principle for people. And then I think still, if that doesn't resolve it, then I think you do what I mentioned earlier, which is you try to get the party to hold the offer open for a period of days, which allows the tempers to come down a little. And then usually they come around and are able to see the forest, the trees.
We are almost ready for final thoughts, but before I ask for those, I got one more question for you, Judge Quereshi. Other than being untruthful and insulting, what are the three biggest lawyer mistakes you have seen on both sides in mediation?
Three biggest mistakes. So I would say not recognizing, number one, not recognizing, and I think I've hit this a number of times already, and so I apologize for being repetitive. I think recognizing the difference in the context between an advocacy setting and a mediation setting. So I'm more than happy to hear about why you think you're going to win the case and not have to pay anything or get all the money you're entitled to. But it's only effective if I can use it to move the other side. And I will do everything I can to use it to move the other side. But at a certain point, it will no longer be effective for the other side because it'll become a matter of dollars and cents. And so I think getting so caught up in why you think you're going to win and treating it as if it's an argument before the Supreme Court or the Fourth Circuit or something like that. So I think recognizing the context that you're in, your legal arguments are only going to carry you so far. That's number one. I think number two is I know that mediation is a frustrating experience for all of us, as I've talked about. But I think that taking out your anger on your mediator. And I think to a certain extent, I recognize that's part of my job, is that I have to filter in what you give me and then give it back to the other side in a rational, digestible way that I think will actually be effective for you. But, I think that at a certain point, taking out your frustrations on your mediator, saying at the end of the day, what a waste of time it was, et cetera, et cetera. I don't know that that's like effective in the long term or the short term. And so I recognize that part of my job is to sort of be the emotional sounding board for everyone. And I've come into every mediation expecting and respecting that responsibility. But there are limits, I guess. And then I think third is there are these cliches that everybody uses. And as a mediator, only having done 70 and tomorrow 71, I already know what those cliches are. I assume that advocates know what they are too. So, for example, and I'll give one on the plaintiff side and one on the defense side. So on the plaintiff side, if you start at, let's say, $1 million, and, the case is really, let's just say, $100,000 case. And I'm just not thinking of any case in particular. And you've moved from like 100 to 1 million to 200,000. And the other side's moved from, let's just say, 10 to 75. And you really want to point out as a plaintiff, hey, we've moved $800,000 and they've only moved $55,000 or $65,000. I understand why you're doing it. I understand why you're saying it. But as a mediator, I know what your case is worth. And it's not effective. So I understand why you started super high. I respect it. It's part of the game. It's part of the language. And mediation is its own language. But, to think as, even as a relatively new, and I try to come into all these things with as little hubris as possible, believe it or not. I've seen that play out a number of times, that I know what that's worth and what that's not worth. And on the other side, I think, for the defense side, so I'm giving one for each side, telling me about how this case is, a waste of everyone's time and how it's a nuisance case. This case, really doesn't belong in court, and it's all of that. Fine. If you need to say that because you really want to get it out, I'm more than happy to hear it. But to think that it's going to meaningfully adjust the way I see the case is not, because my goal is to help everybody get to a resolution. And me running to the other side and saying things like, this is a nuisance case isn't going to do anything to persuade the other side. And so I think so that's the third one I would give you, is avoiding those catchphrases, which I assure you, your mediator has heard before.
Thank you. We are ready for final thoughts. Reuben, start us off.
Thanks, Scott. So for mediation, when you're plaintiff's counsel and you're gearing up for mediation, I think my biggest recommendation, especially when an insurance adjuster is involved, is be transparent with the mediator and with the other side about your numbers. If you've got an opening demand of $750,000, it's going to be taken better on the other side if you're providing a damages calculation, which is provided for, confidentially for purposes of the mediation, that shows how you're arriving at those numbers. And if they're grounded in actual damages, fair enough. And you need the other side to understand what you're valuing the case at, and what the amount in controversy is actually going to be at stake if this thing moves forward. Now, they've, of course, done their metrics and calculations on the other side, and there may be disagreements on the numbers. But the more transparent you can be with a demand, the better it's going to be received, and the more likely the chances are that your case is going to resolve at mediation. And I think another really valuable part of a mediation is oftentimes clients, I think this is true on both sides of the fence, sometimes don't hear or carefully listen to their own attorneys on the risks or weaknesses of their case. They're only focused on the strengths and how they're going to win their case. And so, Judge Quereshi talked a lot about how it's usually later in the day in a mediation where he's going to be very forthright and candid about, okay, here are the touch points I see that are problematic for you moving forward. It can be really effective for a client to hear that from someone other than you as their advocate. So when the mediator is outlining their concerns about the strengths or weaknesses of a case as you perceive them to the client, it can be really effective in helping resolve the case, or at least reinforcing, the risk assessment that you've given to the client. If the client says, you know what, I'm the decision maker here today, I'm going to move forward with my case and proceed with summary judgment or discovery or whatever phase you're at, right? And so I think that's a really important part of mediations as well that can be effective in helping resolve them. And I like to try to prep clients for that by saying, it's good if the mediator is doing that in our room. And just keep in mind, it's very likely the mediator is doing the same thing in the other room. It's not a personal thing. You're not being attacked. It can be beneficial for both sides to hear those things. And those are the cases that usually resolve at the end of the day.
Reuben, thank you. Nat?
Well, thanks again, everyone, for having me here today. This has been fun. I would just sort of strapping on to what Reuben just said in terms of transparency. Surprises are not a good thing for mediation. So, and I sort of touched on this before, but when you get there and the demand all of a sudden goes up from what you had before, or you get presented with some new piece of evidence that you're seeing for the first time, or an affidavit from a witness, these, particularly when there's an insurance carrier involved, these are pretty large bureaucracies that have to get authority ahead of time, and they're not going to be able to just turn on a dime because you presented a new piece of information that they didn't have before and get additional authority in the case. So, the more information that both sides have going into it, I think the more possibility of it being successful there will be.
Judge Quereshi.
Did most of what I wanted to say already. I just wanted to thank Mr. Calamis, you, Mr. Oswald, Ms. Kelly, and Mr. Wolfson. All of you are incredible, incredibly knowledgeable, and I'm grateful to be on the panel with all of you. I'd just say, again, the vast majority of my cases do settle. And I've never had anyone afterwards communicate in any way to me that they were unhappy that the case settled. It's always been a sign of relief no one thinks that in that moment, there's frustration when, they finally get to that number and everybody signs off on it. And there are bad feelings in that moment. But afterwards, I've never had anyone say, I really regret that I settled that case. So I think that, I think that's going to be easier for the attorneys and the insurance adjusters to know because they've been through it many times before. The client won't know it for good reason because they likely have not been through that scenario before if it's an individual client. So I think being able to have that hindsight in that moment when you're really frustrated can be really effective.
Thank you. Deborah, this has been a fun one. Your thoughts?
We don't have time for my thoughts, but I think it has been very fun and very informative. I think it's very interesting when insurance companies get involved because sometimes as a defense lawyer, I feel like I have two different adversaries instead of somebody behind me on my side, and it can be a big problem. But that's for another day, another time. Anyway, and I appreciate what all the panelists said, and I hope everyone who joined in has learned something, and I hope you all think about becoming a member of the College of Labor and Employment Lawyers.
Thanks to Judge Quereshi, thanks to Nat Calamis, and a special thanks to Reuben Wolfson, who organized this webinar for us. Thank you to Deborah Kelly and our co-sponsor, the College of Labor and Employment Lawyers. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today. See you next time.